Mr. Chairman, there are 13 ayes and 9 noes.
The motion to table
Mr. Chairman,
passes. Yes, who seeks recognition?
I seek to strike the last, I move to strike the last word.
The ranking member is recognized.
Mr. Chairman, in this last amendment by Ms. Scanlon that was just ruled out of order, you ruled it out of order because it references a specific date. In my parliamentary universe, adding a specific date is considered a limiting amendment. It limits the scope of the underlying amendment. It does not expand it. Therefore, it cannot be a grounds for holding an amendment out of order because it limits it. It doesn't expand it. It's called in parliamentary terms a limiting amendment, which is always permitted. So this is just another example of the Republicans using obviously specious reasoning because you're afraid to vote on anything to do with January 6th. You're afraid to vote on all the things we've talked about before because your constituents might hold you responsible. So I would ask you why this is not a limiting amendment. Why this, in what way this expands the scope of the amendment, and I'll yield to you for the purpose.
I'll be happy to answer. We will belabor the point further. I've already explained this, that by presenting this amendment, it changes the purpose of the bill and makes it about January 6th. On its face, by your explanations, by all the comments that have been made, you want this to be about January 6th. You just said it again. You emphasize the same point. That's not what the underlying legislation is about.
Reclaiming my time.
You asked me to respond, and I'm giving you a response. Okay, so
responded.
on its face, the amendment violates House Rule 16, Clause 7. Now, you can disagree with me, but you're not the chairman anymore. I'm sitting in the chair now.
Reclaiming my time. I certainly do disagree with you. And again, I repeat that the motives of the Republicans today are shameful as seeking only to avoid voting on all these different subjects that have been raised today. I yield back.
Would the gentleman yield?
Gentleman,
Would the gentleman yield?
the gentleman has yielded back. Does anyone else seek recognition? Ms. Cicilline, and then I'll get to you, Ms. Johnson.
I have an amendment, so I think Mr. Johnson wants to speak with respect to this, so I'm happy to defer to him.
Gentleman's recognized.
Thank you. The blatant hypocrisy on display throughout this hearing is mind-numbing, Mr. Chairman. It's very disappointing that the intellectual dishonesty that is on display is shockingly abusive to the process. I mean, you can't tell the American people who are looking at this that to include federal law enforcement officers in a resolution honoring the service of local and state law enforcement officers is irrelevant or non-germane or out of order in some way. The American people understand that law enforcement is law enforcement. They understand that January 6th, Capitol Hill police officers died. They understand that federal law enforcement officers over the years have died. Actually 650 have died from gunfire over the years. 650 have died from gunfire, federal law enforcement officers. Not to mention the 7 fallen officers of the U.S. Capitol Police Department, 2 of whom have passed away within the last 2 years due to the insurrection. And so we've had law enforcement officers, federal law enforcement officers, who've given their lives to protect us. They were the ultimate displays of courage. But yet this committee doesn't have the courage to vote up or down a germane amendment that simply seeks to add federal law enforcement officers to this resolution. It's simple. The American people understand it. They're not getting thrown off track by talking about crime. And by the way, the crime that you speak of is caused by your policies in opening the floodgates for more guns on the street. This is a failed experiment. More guns does not mean more safe. More guns means less safe. But yet, the response of the Republicans is always more guns. We should be, instead of a resolution to honor police today, just state and local, we should actually be using our time to make our police officers and to make the citizens of this country more safe by limiting guns, by reversing the trend that you all have started and that you continue to adhere to that makes us less safe. It's ridiculous that we would honor police officers at a time when we're making them less safe and refusing to do anything about it other than to offer prayers and to talk about how brave they are when they respond to the next mass casualty event, which could be taking place right as we speak and could be confronted by federal law enforcement officers coming to the aid of state and local officers. Every mass shooting that we have seen has involved a response by the FBI and the ATF, but yet you want to defund those two agencies. So we've been doing a lot of talking today. The American people see through it. If we're going to honor police, let's honor our state, local, and federal police. Moreover, let's get past these messaging bills and let's start doing what the American people want us to do, and that is pass some gun reform legislation to keep our communities safe. Democrats have been making our communities safer, voting on legislation to make our communities safer, while Republicans have been stopping the legislation either in the House or in the Senate. It's time for it to end. It's time for the killing to stop. It's time for the philosophy of more guns means more safety to go by the wayside. Less guns will make us more safe. And with that, I yield back.
Gentleman yields back. The chair is going to respond to the outrageous claim that there's hypocrisy going on here. All the clutching of pearls is so far out of order, and I'm going to clarify the record here for anyone who's watching at home, high school students who are studying civics, and some on this committee who should understand the rules. The rule is, again, let me state very simply what the rule is. House Rule 16, Clause 7 says that an amendment cannot introduce material beyond the scope and purpose of the bill before us. Let me tell you why the last amendment, by way of example, was ruled out of order. I've already explained this again, but I'll give you further detail. Ms. Scanlon's amendment says on page 2, strike all that follows in the underlying bill after the resolving clause and insert the following, that Congress acknowledges the United States Capitol attack on January 6, 2021. The underlying bill says something very different. It says, be it resolved that Congress recognizes and appreciates the dedication and devotion demonstrated by the men and women of local law enforcement who keep our communities safe, and 2, condemns calls to defund, disband, and dismantle or abolish the police. The reason, everybody watching at home, the reason that they're so anxious to change the language of the underlying legislation is because of the last sentence that I just read you, that last clause, because this resolution condemns calls to defund, disband, dismantle, or abolish the police. They're all on record, including the ranking member who just clutched his pearls and told me that I was out of order here.
Would the gentleman
he is
yield?
on record saying that he wanted to defund the police. I'm not going to yield. You guys have talked enough. And you've all accused us of abusing the rules. This amendment, just like the ones before it, is a blatant violation of House Rule 16, Clause 7. It is not germane because it wants to talk about January 6th and it wants to get rid of the condemnation of the call to defund police, which was their mantra here until just recently.
Would the gentleman
because now we've seen the results.
Mr. Chairman, will you yield to a
The
question?
chair does not yield. I will yield if you have an amendment. No, I'm not going to yield to a question. No, you've talked enough, Mr. Cicilline.
You don't get to decide that, Mr. Chairman. You don't get to decide who talked
It's my
enough.
time, and I'm not yielding.
Okay, then I ask recognition.
I'll yield back. The gentleman's recognized.
Thank you. So I haven't talked enough, apparently. First of all, Mr. Chairman, this notion that the claim you just made that because you've concluded the amendment changes the purpose of the bill as a basis for ruling it not germane is just wrong. There's no such test. It's not whether or not you think it changes the purpose of the bill. God knows how we would determine what the purpose of the bill is. We thought the purpose of the bill was, in fact, to praise police, to praise local police. But now you secretly let out what the real purpose of it is. It's to claim that Democrats want to defund the police. That's not the purpose of the bill. This is for Police Week, to praise local law enforcement.
And support them.
It's my time. Don't try it. The jig is up. You've been exposed. We have, ladies and gentlemen, on the Democratic side, sorry, we've been laboring under the assumption that this was about praising local law enforcement.
It's
because
both.
that's not what it's about. So I'm going to give you one more chance, Mr. Chairman, yet again to redeem yourself in these rulings and offer an amendment.
Oh, the gentleman has an
Oh, no, I'm happy to yield to him.
Just briefly, I mean, the chairman's comments that we were, scared of that language. I mean, the amendment I offered maintained all of that language. In fact, you guys blocked or voted down, I think, 4 amendments that maintained the same language. So that's clearly wrong.
Well, but your amendment did other things that were beyond the scope as well.
No.
And look, asked and answered.
I'm not raising that again. That's clearly not correct. But, I just wanted to point out that the statement you made about we're scared of no, it was in the language that you blocked us from offering to vote on.
Thank you, Mr. Ivey. Excellent point.
Okay,
I reclaim my time.
Well, you gotta
I
go
now
back
have an
and then-
amendment, Mr. Chairman, which is at the desk.
Procedurally, though, yield back, and then I'll recognize you for the amendment purpose.
Okay, I yield back.
All right. And the gentleman has an amendment at the desk? The clerk will report.
Is your amendment ready?
Amendment to H. Con. Res. 40, offered by Mr. Cicilline of Rhode Island.
Without objection, the amendment be considered as read. And the gentleman,
Point of order.
point of order is reserved by Mr. Bach, and the gentleman is recognized to explain his amendment.
Thank you, Mr. Chairman. I think this should finally withstand this effort to have all Democratic amendments declared not germane because you've already accepted the language in the Swalwell amendment. This simply adds language that says, whereas gun violence continues to be the leading cause of line of duty deaths, 64 law enforcement officers were shot and killed while serving their communities. Gun violence continues to pose a serious threat to law enforcement, children, families in our communities. And whereas the law enforcement deaths by gun violence reflect a 21% increase over historical average of firearms-related deaths between 2010 and 2020. And just to avoid any concern, we omit reference to state police agencies and just refer to local police agencies. And in the final paragraph, again, say local police officers. I think we finally fit through the eye of the needle. It's all about local law enforcement, language you've already accepted with respect to the Swalwell Amendment. So I look forward to not only a ruling that it's germane, but also your support. And I yield back.
Mr.
Gentleman
Chairman, I
yields
insist on
back.
my point of order.
Gentleman insists on his point of order. You're recognized.
The underlying resolution, the underlying bill is to praise police and to condemn the effort to defund the police. It is not about January 6th. It is not
This is not about January 6th.
It is not about
Gentleman's time.
strategies to address gun violence. It is about praising the police, plain and simple. I will read, if I can find underneath all these amendments.
You want the underlying legislation?
Yeah, thank you. I will read the resolved 2 paragraphs again. Congress recognizes and appreciates the dedication and devotion demonstrated by the men and women of local law enforcement who keep our communities safe and condemns calls to defund, disband, dismantle, or abolish the police. That is the purpose of this, and the offered amendment is not germane. I
Mr.
yield
Chairman,
Does the sponsor of the amendment wish to be heard on the point of order?
Yes, I don't know how, this will be an interesting thing to watch, Mr. Chairman, because you've already ruled that the amendment offered by Congressman Swalwell was germane, and that this amendment that I offered today, again, speaks about protecting police officers, and I will just read it. Whereas police officers face increasing danger as guns proliferate across our nation, whereas the police organizations, including the Fraternal Order of Police, the International Association of Chiefs of Police, and major city chiefs have supported legislation to curb gun violence by expanding background checks and enacting extreme risk protections while opposing bills that would require states to recognize all concealed carry permits from other states. Whereas despite the objections and safety concerns expressed by local police agencies, organizations, and officers, right-wing state legislatures have eliminated permit and training requirements to carry handguns in public. And whereas high-powered firearms with armor-piercing bullets pose a continued risk to police officers, you have already ruled that language that really just strengthens the underlying purpose of the resolution is in order. So I don't know how you can now determine, other than you like Eric Swalwell and you don't like me, which I hope is not the case, but I'll yield to Mr. Nadler.
Certainly not.
Thank you. I agree with everything that Mr. Cicilline said. I just want to tell you the hypocrisy here. We've been in contact with a former parliamentarian of the House who's been watching these proceedings on TV, and he says every single amendment was in order because striking a clause in the preamble is per se germane, neither adds nor subtracts, and police, by definition, means all police, and that includes the January 6th police, it includes anything else. So I just want to tell you that's just another confirmation of your hypocrisy. I yield back to Mr.
And I yield as much time as she may consume to the gentlewoman from North Carolina.
Thank you, Mr. Cicilline. Just want to remind the committee that last time we took up bills for National Police Appreciation Week, we took up the actual bills that the police asked us to take up, and we did pass them through the House. And this amendment involves the actual bills that the police would like us to take up, including all of my local law enforcement. And I just want to thank Mr. Cicilline for the second year in a row for listening to local law enforcement and bringing before this committee the things that local police actually care about. And I yield back to Mr. Cicilline.
Thank you. And I would just say, Mr. Chairman, to conclude that this amendment is not germane, you would have to conclude that recognizing the dangers that local law enforcement face from gun violence is wholly unrelated to any resolution which recognizes their heroism and thanks them for their service to our communities. That just is impossible to reconcile unless you make a complete mockery of the dangers that the men and women who serve in local law enforcement face every day. The two are completely connected. And so this one I want to watch as you rule.
Does that mean the gentleman yields back?
And I would just say finally that you specifically talk about putting local law enforcement in particular danger in the very language of the underlying resolution. So how is it possible when my amendment simply amplifies another danger that law enforcement faces every single day, that somehow it is wholly unrelated so as to be a different subject matter not properly considered during this markup? And I yield back.
Gentleman yields back. Does anyone else seek recognition on the point of order? Chair is prepared to rule. Mrs. Cicilline, you paying attention? You wanted to hear this. You wanted to see it. Okay. The amendment does not satisfy the subject matter and fundamental purpose test. Before you balk, wait, let me explain. Because you cut out the second resolution clause, the important sentence about defunding police that the sponsor of the legislation just said was central to his. This is not a whereas clause, this is a resolution. You're changing the scope of the legislation by striking that out.
Mr. Chairman, you can always limit the scope of a bill by an amendment. You can always limit it. That doesn't go to its...
It changes the purpose of the gentleman's
There's
bill.
no
as he
such
just
thing
said.
that says you can't change the purpose.
That's a
There's
matter
no
of
such
opinion
thing.
and should be voted on.
You don't get to decide what the purpose of the underlying resolution is and whether
No,
it's
sir.
changed.
No, sir.
Mr. Chairman, since when do we have argument while the chair is making a ruling?
The chair started being so absurd.
Oh, wait a minute. Hold on. Wait a minute, Mr. Ranking Member. I sat under lots of absurd decisions from you. All right. Let me read you Section 7 under House Rule 16. It's Clause 7, fundamental purpose. Another test used by the chair in determining germaneness is one in which the fundamental purpose of the bill is compared with the fundamental purpose of the amendment. See Manual Section 933. If the purpose or objective of an amendment is unrelated to that of the bill in which it is offered, the amendment may be... Let me finish. That's 8 Canon, Section 2911. The test is particularly applicable to an amendment in the nature of substitute. Okay. If the purpose... Well, it gives lots of examples. All right, let me say this. The parliamentarian who's watching on television, who is, I'm sure, a Democrat parliamentarian or would not have had Mr. Nadler's cell number, let me tell you that this does, in the view of this chair and this parliamentarian, expand or change the purpose of the bill before us. And so our interpretation of House Rule 16, Clause 7, is that it is not germane. Now, the other side is going to disagree, but that's the beauty of our system. The majority party is in the chair, makes decisions, it's appealable, it's subject to table. We've gone through that process here. This is the way this works, and always has. And there are thousands of examples of this and precedent that has been set in the Judiciary Committee in its storied history. So,
Mr. Chairman,
you're not recognized. So for all of the drama here, that is the ruling of the chair, and I yield back.
I appeal the ruling of the chair.
The ruling is appealed. Does the gentleman seek to table? Motion to table. The appeal is made, and the clerk will call the roll.
Mr. Jordan? Mr. Jordan? Yes. Mr. Jordan votes yes. Mr. Issa? Mr. Buck? Yes. Mr. Buck votes yes. Mr. Gates? Mr. Johnson of Louisiana?
Yes.
Mr. Johnson of Louisiana votes yes. Mr. Biggs? Mr. Biggs votes yes. Mr. McClintock? Mr. Tiffany?
Aye.
Mr. Tiffany votes aye. Mr. Massey? Mr. Roy? Mr. Bishop? Ms. Spartz? Mr. Fitzgerald? Mr. Bentz? Mr. Klein? Mr. Klein votes aye. Mr. Gooden? Mr. Van Drew? Mr. Van Drew votes yes. Mr. Nels? Mr. Nels votes yes. Mr. Moore? Mr. Moore votes yes. Mr. Kiley? Ms. Hageman? Ms. Hageman votes yes. Mr. Moran? Ms. Lee? Mr. Hunt? Mr. Hunt votes yes. Mr. Fry? Mr. Fry votes yes. Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren? Ms. Jackson Lee? Mr. Cohen? Mr. Johnson of Georgia? Mr. Johnson of Georgia votes no. Mr. Schiff? Mr. Schiff votes no. Mr. Cicilline? Mr. Cicilline votes no. Mr. Swalwell? Mr. Swalwell votes no. Mr. Liu? Ms. Jayapal? Mr. Correa? Ms. Scanlon? Mr. Nagoose? Ms. McBath?
No.
Ms. McBath votes no. Ms. Dean? Ms. Escobar? Ms. Escobar votes no. Ms. Ross? Ms. Ross votes no. Ms. Bush? Mr. Ivy?
No.
Mr. Ivy votes no.
Any member who hasn't been before? Any member, gentleman from California.
Mr. Issa votes yes.
Is Mr. Swallow? No, who are we looking for? Mr.
Mr. Gooden?
Mr. Gooden?
Mr. Gooden votes yes.
Okay, I think any member, Mr. Biggs, gentleman from Arizona? He voted. You voted? Okay. I think the clerk can report.
Mr. Chairman, there are 14 ayes and 9 noes.
The motion to table prevails. reporting. Oh. Gentleman from California is recognized.
Mr. Chairman, I have an amendment at the desk.
Clerk will report.
Amendment to H. Con Res 40, offered by Mr. Schiff of
Gentleman from
California.
Arizona reserves a point of order. Without objection, the amendment will be considered as read. The gentleman from California is recognized for his amendment.
Thank you, Mr. Chairman. The amendment is very simple. It inserts language expressing opposition to the Abolish the ATF Act of 2023, which would eliminate the Bureau of Alcohol, Tobacco, and Firearms and Explosives. Immediately after that bill's enactment, it expresses opposition to that bill as a dangerous effort to defund the police and harm local law enforcement. And just in case members are unfamiliar with what we would be abolishing under that legislation, the ATF's responsibilities include investigation and prevention of federal offenses involving the unlawful use, manufacture, and possession of firearms and explosives. I was led to believe for many years that the Republican mantra was, we don't need any new gun laws, we should enforce the ones that we have. But apparently today they don't even want those laws enforced. More than that, the ATF also combats illegal trafficking of alcohol and tobacco. I guess my GOP friends don't think we should be doing that either. The ATF also operates a fire research laboratory where they examine ways of detecting criminal arson. I guess we want to abolish their ability to do that. ATF uses its legislative mandate to investigate and recommend prosecution of offenders to reduce the level of violent crime and hence public safety. I guess we want to abolish those efforts. ATF strives to increase state and local awareness of available federal prosecution under the statutes and works to curb the illegal use of firearms, enforce firearm laws. ATF issues firearms licenses. I guess we don't want to issue any firearms licenses anymore either. They also work on combating the import, manufacture, and dealing in explosive materials. So I guess we're going to abolish those efforts. As well as the special response teams, which are elite tactical groups that respond to high-risk law enforcement operations. So we don't want them to be able to do that in conjunction with local law enforcement. So that's what that bill would do, Mr. Gates' bill. It is, one of the clearest efforts to defund law enforcement. And given that this underlying bill is about expressing our opposition to efforts to defund law enforcement, I presume I'll have the support of my colleagues to express opposition to that effort. And I'm happy to yield to my Republican colleagues if they want to express support for Mr. Gates' efforts to defund the ATF. Would any of my Republican colleagues like to express their support for Mr. Gates' efforts to defund the ATF?
I think we're going to get to that.
I
think we're going to get to that,
Mr. Chairman, Mr. Jordan, would you like me to yield to you, express your support for Mr. Gates' legislation to defund the ATF?
I'm going to yield to Mr. Gates.
No, I'm yielding to you, Mr. Jordan.
Well, I'm going to listen to Mr. Gates' compelling arguments that I know will be coming, and then we will have a debate.
Reclaiming my time, I'd be happy to yield to you for the purpose of
I appreciate your willingness.
Mr. Jordan, if you let me finish.
I will.
It is my time. I'm happy to yield to you for the purpose of saying yes or no whether you support Mr. Gates' efforts to defund the ATF. Do you, Mr. Jordan?
I support Mr. Gates' effort to send a message to the ATF, which is what he said
so
just a
you
few
do
minutes
support,
ago in the
you
debate.
support the legislation to defund the ATF?
I didn't say that. I said I support his efforts to send a message to the
ATF.
ATF.
The bill that Mr. Gates has introduced
changed the rule after 10 years of telling American citizens
that it would abolish, it would eliminate the Bureau immediately after enactment. Do you support that, Mr. Jordan? Yes or no?
I've given my answer.
Do you support it?
I've given my answer.
Yes or no, Mr. Jordan?
I've given my answer, Mr. Schiff.
Okay, I guess your answer is you don't support it, or you're afraid to say that you do. But I'm happy to yield to Mr. Johnson or Mr. Biggs or Mr. McClintock, Mr. Tiffany, or Mr. Massey. Anyone else like to join Mr. Gates? And anyone like to express their support for Mr. Gates' effort to abolish an entire federal law enforcement agency? Anyone over there? Mr. Issa, do you support abolishing the ATF?
Thank you for yielding.
It's a yes or no, Mr.
You and I have
Issa.
served here for almost 22 plus years.
Reclaiming my time, I'm not getting a yes or no from anyone.
I was getting to that.
Well, yes or no?
I'm sorry,
yes
but
no, Mr. Issa.
What I was saying is
Yes
that
or no?
it took 22 years to see you
yes or no, Mr.
conducting a
Hanson?
deposition of your colleagues, and I appreciate
reclaiming
it,
my
Mr.
time.
U.S. Attorney.
Reclaiming my time. Apparently, Mr. Gates is the only one willing to publicly say he supports defunding the ATF. Maybe that's progress, and I hope that will mean
Well, the
that,
gentleman,
that
I
my
think there's going to
colleagues
be a
will
vote. I think there's
accept-
going to be a
I-
vote.
I
You're
hope-
going to know here in a couple
I hope
of
that
minutes.
my colleagues will accept the amendment. The
gentleman's time has expired. The gentleman from
Excuse me,
Arizona-
I'm reclaiming my time, Mr.
You don't
Chairman.
have any time to reclaim.
Well, I would if you hadn't been speaking over it.
No, you ask us all the questions.
Well, and what's the answer,
The
Mr.
gentleman
Jordan?
from Arizona
What's the answer? Do you support
withdraws his point of order.
abolishing the ATF, Mr. Jordan?
The gentleman from Florida is recognized.
Thank you. I greatly appreciate this interest in the legislation I've offered, and many of the features of government that are important that Mr. Schiff points out occur in other areas. They don't occur only in the ATF. Now, the ATF is an agency that has totally exceeded any sense of authorization. And by the way, it's not even an authorized entity of government. It just continues to get funded. And what have they done with that funding? Not according to me, but according to the Department of Justice's own Inspector General, they have failed to secure their facilities, and then they have violated people's civil liberties and rights by maintaining electronic records that they have no legal authority to maintain. Did they do that to just a few of them?
Will the gentleman
No,
yield?
hundreds of thousands of times they broke the law.
Mr. Gates,
and the
would you yield?
reason that that's problematic
Time
in a
belongs to the gentleman from
circumstance
Florida.
in
Mr.
which
Gates?
the ATF continues to grow beyond their limits is
Mr.
because
Gates, would
they
you
are
yield?
now imposing on, I'm defending my bill, Mr. Schiff, they are now imposing on regular Americans a sense of zero tolerance that isn't for public safety. They're putting people out of business, like those who are contacting each of our offices who have some Scrivener's error or technical violation that oftentimes isn't even the fault of the individual that the ATF is bringing hellfire down on from a regulatory sense. So yes, I do believe that the current structure of the ATF is absolutely not worth vindicating or funding or continuing in its operational setting.
In that case, would you yield, Mr. Gates?
I'll yield, Mr. Schiff.
Mr. Gates, can you identify any of your Republican colleagues on this committee who are supporting your bill?
Well, I can identify one, and then I'll get back to my remark. Mr. Biggs is a co-sponsor. I don't know if anybody else is. I'd invite your co-sponsorships.
Okay, so there-
frankly.
there-
There are people here supporting. Look, we're going to
So
see
there
in the
are
vote.
two
but the
Republican
important
members
thing is-
who favor abolishing the
Gentlemen,
entire
I
police
can't list every
agency.
supporter. I tell you what, you can get on the
Any other
legislative format.
takers?
I control the time. And you can get on and see that there's a handful of members who've co-sponsored the legislation. I would encourage everyone to do so because the ATF has been weaponized. And again, I repeat, this is not a partisan conclusion. The Department of Justice Inspector General was appointed by President Obama. He's an Obama appointee. And not only do they point out the high frequency at which the ATF violates the law, then they point out the recalcitrance of that agency to even follow the recommendations that have been set forth by the Inspector General. So sometimes when you get an agency that goes rogue, as the ATF has, it is the right time to start with a fresh sheet of paper. And that is not to say that every function of the ATF is a bad function of government. It is saying that this particular agency cannot meet those functions, and that's a position that's held not just by me, not just by my co-sponsors, some of whom, at least one of whom, is on this committee. It's something that, at least in the factual articulations of the deficiencies of the agency, is articulated by inspectors general. There's also a GAO report. There's also a GAO report that goes over records maintenance that excoriates the ATF. And that is also not a partisan entity. That is a nonpartisan entity that has a watchdog.
Would the
or
gentleman
oversight.
yield for a question?
I'll yield.
If you acknowledge that there are multiple functions that the ATF currently performs that should not be abolished, wouldn't it have made sense to say in your bill, other than we're abolishing the ATF immediately, to provide some sort of transition for those functions to other agencies, to transition for the funding,
I would say
pending
that,
cases
I would say that
are in
that
court?
is certainly something I'd be willing to work with you on. I'm open-minded as
I
to
don't
the
want to get
transfer
rid of the
those
ATF,
functions.
so I'm not working
Well, that's
with
the
you on
problem,
that.
right? You don't want to get rid.
We can-
Democrats, I'm sorry, I'll address the chair as we're entitled to do. My objective here with House Democrats is to try to build a system that adheres to the values that many House Democrats used to espouse regarding protecting individuals from too much government surveillance and too much government overreach. and the ATF has done that. That has been the conclusion of multiple entities that have observed their conduct. They haven't fixed the things that they were told wrong. And so, yes, I would start with a blank sheet of paper, and I don't think support for my measure in any way binds someone to the theory that these functions of government are not appropriate. But I do not trust the ATF to do those things. I really don't. I think that they're too busy going after law-abiding gun owners, and because I don't trust them to do the important things.
So you literally want to abolish, now earlier you said it was a shot across the bow. You literally want to abolish the agency in toto, immediately.
I would get rid of the funding we currently have through ATF for those functions, and I would reorient it where it does not go through ATF. And I would start that work tomorrow.
Gentleman's time has expired. Who seeks recognition? Question occurs on the amendment from the gentleman from California. All those in favor say yes.
Aye.
Or aye. All those opposed say no. No. The opinion of the chair is the noes have it.
Mr. Chairman, on that, I request record a vote.
Recorded vote is requested. The clerk will call the roll.
Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Issa? Mr. Buck? No. Mr. Buck votes no. Mr. Gates? Mr. Gates votes no. Mr. Johnson of Louisiana? No. Mr. Johnson of Louisiana votes no. Mr. Biggs? Mr. McClintock? Mr. Tiffany?
No.
Mr. Tiffany votes no. Mr. Massey? Mr. Roy? Mr. Bishop? Ms. Sparts? Mr. Fitzgerald? Mr. Bentz? Mr. Klein? Mr. Klein votes no. Mr. Gooden? Mr. Van Drew? No. Mr. Van Drew votes no. Mr. Nels? No. Mr. Nels votes no. Mr. Moore?
No.
Mr. Moore votes no. Mr. Kiley? Mr. Kiley votes no. Ms. Hageman? Ms. Hageman votes no. Ms. Moran? Ms. Lee? Mr. Hunt? Mr. Hunt votes no. Mr. Fry? Mr. Fry votes no. Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Ms. Jackson-Lee? Mr. Cohen? Mr. Johnson of Georgia? Mr. Johnson of Georgia votes yes. Mr. Schiff?
Aye.
Mr. Schiff votes aye. Mr. Cicilline?
Aye.
Mr. Cicilline votes aye. Mr. Swalwell? Mr. Swalwell votes yes. Mr. Liu? Ms. Jayapal? Mr. Correa? Ms. Scanlon? Mr. Neguse? Ms. McBath?
Yes.
Ms. McBath votes yes. Ms. Dean? Ms. Escobar? Yes. Ms. Escobar votes yes. Ms. Ross? Aye. Ms. Ross votes aye. Ms. Bush? Mr. Ivy?
Aye.
Mr. Ivy votes aye. Mr. Issa, you're not recorded. Then I'll vote no. Mr. Issa votes no.
Mr. Chairman, how am I recorded? Gentlelady from Texas.
Ms. Jackson-Lee, you're not recorded.
I'll vote aye,
Ms.
enthusiastically.
Jackson-Lee votes aye.
Gentlelady from Pennsylvania.
Ms. Dean, you're not recorded. Ms. Dean votes yes.
We good? Excuse me. Clerk will report. Oh, I'm sorry, that's right.
Ms. Jayapal votes yes.
I know, I guess so. I'm checking. We okay? Clerk will report.
Mr. Chairman, there are 12 ayes and 14 noes.
The amendment is not agreed. Amendment's not agreed to. Okay. Getting them all in before you go, aren't you?
Chairman, I'm a
keep
slow
on
learner.
coming.
I think I have an amendment at the desk that will be germane if I follow the logic.
Gentleman from Rhode Island, when does the gentleman actually head back to Rhode Island. Not that we're
May 31st.
I thought it was this month.
Yeah.
Well, we're gonna miss you, but
Thank you, Mr. Chairman.
we'll still see what this amendment's about. Gentleman is recognized.
Thank you, Chairman. I have an amendment at the desk.
Clerk will report. Gentleman from Florida reserves a point of order.
Amendment to H. Con Res 40 offered by Mr. Cicilline.
Without objection, the amendment be considered as read. The gentleman from Rhode Island is recognized.
Thank you, Mr. Chairman. This amendment is the same amendment I just offered a moment ago with one modification to respond to the parliamentarian's concern, the acting chairman's concern when he ruled it not germane. He ruled it not germane because it struck language at lines 7 through 8 and changed the purpose of the bill, according to Mr. Johnson. So this amendment just introduces new language. It does not strike lines 7 through 8. It's otherwise the same amendment, so I think it is now germane, and I urge my colleagues to support it.
I'll withdraw my point of order.
The gentleman from Florida withdraws his point of order. Who seeks recognition? The gentleman from Louisiana is recognized.
I'd just like to point out to Ms. Cicilline, the system does work, my friend. The system does work.
Gentleman yields back. Question occurs on the amendment. All those in favor say yes.
Aye.
All those opposed, no. No. In the opinion of the chairs, the noes have it.
Mr. Chairman, I ask for a recorded vote.
Gentleman from Rhode Island asks for a recorded vote. Clerk will call the roll.
Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Issa? Mr. Issa votes no. Mr. Buck? Mr. Buck votes no. Mr. Gates? Mr. Gates votes no. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes no. Mr. Biggs? Mr. McClintock? No. Mr. McClintock votes no. Mr. Tiffany?
No.
Mr. Tiffany votes no. Mr. Massey? Mr. Roy? Mr. Bishop? Ms. Spartz? Mr. Fitzgerald? Mr. Bentz? Mr. Klein? Mr. Klein votes no. Mr. Gooden? Mr. Van Drew? Mr. Van Drew votes no. Mr. Nels? Mr. Nels votes no. Mr. Moore? Mr. Moore votes no. Mr. Kiley? Mr. Kiley votes no. Ms. Hageman? Ms. Hageman votes no. Mr. Moran? Ms. Lee? Mr. Hunt? Mr. Hunt votes no. Mr. Fry? Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Ms. Jackson Lee? Ms. Jackson Lee? Ms. Jackson Lee votes aye. Mr. Cohen? Mr. Johnson of Georgia? Mr. Johnson of Georgia votes aye. Mr. Schiff? Mr. Schiff votes aye. Mr. Cicilline? Mr. Cicilline votes aye. Mr. Swalwell? Mr. Swalwell votes aye. Mr. Liu? Ms. Jayapal? Ms. Jayapal votes aye. Mr. Correa? Ms. Scanlon? Mr. Nagoose? Ms. McBath?
Aye.
Ms. McBath votes aye. Ms. Dean? Ms. Dean votes aye. Ms. Escobar? Ms. Escobar votes aye. Ms. Ross? Ms. Bush? Mr. Ivy?
Aye.
Mr. Ivy votes aye.
All members voted. Clerk will report.
Mr. Chairman, there are 11 ayes and 14 noes.
The amendment is not agreed to. Reporting quorum being present, the question is on favorably reporting the resolution. All those in favor say yes. Yes. All those opposed, no.
No.
Opinion of the chair, the ayes have it, and the resolution is ordered to be reported favorably to the House. Members will have 2 days to submit views without objection. Do you want a roll call?
There wasn't.
Roll call, please.
Roll call being requested. The clerk will call the roll.
Never mind.
Roll call being withdrawn. The resolution passes, and the resolution is ordered to be reported favorably to the House. Members will have 2 days to submit views without objection. Staff is authorized to make technical and conforming changes. We need Mr. Fitzgerald. Harriet Scott, okay. Pursuant to notice, I call up H.R. 288, the Separation of Powers Restoration Act, for purposes of markup, and move that the committee report it favorably to the House. The clerk will report the bill.
H.R. 288.
Without objection, the
amend.
bill will be considered as read and open for amendment at any point. The chair now recognizes the gentlelady from Wyoming, Ms. Hegeman, for an opening statement.
Thank you, Mr. Chairman. I strongly support Representative Fitzgerald's Separation of Powers Restoration Act, and I'm proud to be a co-sponsor of this important legislation. Judicial deference is a harmful doctrine, placing the American people at a distinct disadvantage in court when going up against what has become an all-too-powerful administrative state. Separation of powers is the foundation of our Constitution, guaranteeing our right to a Republican form of governance while checking the tyranny of mandates by fiat. The modern administrative state stands in stark contrast to this model, and the creation of the deference doctrines has only further upended this separation of powers, pursuant to which federal agencies oftentimes not only diminish, but sometimes outright ignore congressional intent, with deference then allowing them to also infringe on judicial review. So I want to thank Mr. Fitzgerald for offering this bill to level the playing field by requiring courts to use de novo review of all relevant questions of law and to discontinue our judicial branch's willingness to allow unelected bureaucrats to do their jobs. I also believe it is important to clarify the intent of this legislation. Providing for de novo review of all relevant questions of law, including the interpretation of constitutional and statutory provisions and rules made by agencies, as the bill outlines, is not intended to be a limiting statement. It cannot be a limiting statement if we are to fulfill our goal of reining in the administrative state. This means addressing the array of issues that may arise under the Administrative Procedure Act. One such issue is the question of agency guidance, described as informal, non-legislative rules or documents which constitute an agency statement of general applicability intended to have future effect on the behavior of regulated parties that set forth a policy on a statutory, regulatory, or technical issue, or an interpretation of a statute or regulation. These forms of guidance don't follow the notice and comment requirements of the APA and don't have the force of law. Yet we have seen a growing trend whereby administrative agencies attempt to use guidance to make new law while at the same time avoiding the APA process, and then argue that such guidance is not reviewable by the courts because it does not constitute final agency action. They compound the problem by then seeking to have the courts defer to their opinions in that regard. Because guidance is, by definition, intended to guide something related to a statute or regulation, it must also be subject to de novo review under this bill's language. It is for this reason that this bill is not limited in scope. It follows from the text of the bill, and it is the intent behind the bill that judicial de novo review of all relevant questions of law includes questions of law surrounding agency guidance. If we are to carry out the mission the American people tasked us with when they gave us the majority, which includes reining in the abusive federal agencies, we must include the growing area of abuse as represented by agency guidance. The fact is that deference unfairly pits the administrative state against the American people. It further undermines our rights by distorting the intent of the laws as written by our elected representatives. It also undermines the very purpose of judicial review by creating systemic judicial bias in favor of administrative agencies, which at this point in time have become far too powerful and far too dictatorial in their actions. Correcting this harmful construct of deference to agencies, including the guidance that they issue, is one of the most important tasks we can take on, and this is an important piece of legislation. I am proud to support this bill and urge all of my colleagues to do so as well. I also request unanimous consent to introduce an article published in the Wall Street Journal on May 9th, 2023, entitled "The Deep State is All Too Real," written by former DOI Secretary David Bernhardt. Thank you, Mr. Chairman, and I yield back.
The lady yields back. The chair now recognizes the ranking member, Mr. Nadler, for an opening statement.
Thank you, Mr. Chairman. Mr. Chairman, H.R. 288, the so-called Separation of Powers Restoration Act, would completely upend the administrative process by eliminating judicial deference to agencies and requiring federal courts to review all agency rulemakings and interpretations of statute on a de novo basis. More than 30 years ago, the Supreme Court held in Chevron USA, Inc. versus Natural Resource Defense Council that courts must give, quote, considerable weight to an agency's construction of a statute it administers. This makes sense because while Congress sets broad policies, we delegate authorities to executive agencies because we do not have the expertise to craft technical regulations ourselves. We do not have the expertise to decide how many parts per billion of arsenic in the atmosphere is safe, or how many parts per billion of lead from automobile tailpipes in the air is safe. Under the Chevron doctrine, courts respect the careful process undertaken by the dedicated professionals at our federal agencies, many of whom have decades of experience and vast technical expertise. And they give deference to an agency's interpretation of its statutory authority if the interpretation is determined to be reasonable. The Chevron doctrine has been the ruling precedent for judicial review of agency decisions for decades. It rests on the presumption that Congress intended to task agencies with enforcing the laws and carrying out the policies that Congress passed. It is therefore in the hands of Congress to change any presumption of legislative intent. But instead of taking a careful and deliberate approach to provide more guidance to agencies and thus reviewing courts as to what Congress wishes agencies to do, the majority is using a broad bill to undermine a long-standing precedent set by the Supreme Court, a move that would throw uncertainty into the entire rulemaking process and grind courts' review of agency action to a stop. In addition, this bill would empower judges to completely override the determinations of agency experts and to substitute their own judgment, regardless of their comparative lack of technical knowledge and understanding of the underlying subject matter. Thus, this legislation would put consumers in danger by allowing a judge to undermine and second-guess the carefully crafted and scientifically based decisions by agencies. It is the height of hypocrisy for the party that rails against what it calls judicial activism to support legislation that is the very embodiment of judicial activism. By eliminating judicial deference to agencies, this bill would empower the courts to make public policy from the bench, ignoring the careful consideration and technical expertise of executive agencies. H.R. 288 would also make the federal rulemaking process even more time-consuming and costly. As leading administrative law experts have found, the current process of agency rulemaking takes considerable agency time and resources. By eliminating deference to agencies, this legislation would exacerbate this problem by forcing agencies to adopt even more detailed factual records and explanations in order to withstand judicial scrutiny, which would further delay the finalization of critical life-saving regulations. These are regulations that protect the quality of the air we breathe, the water we drink, the food we consume, and the safety of the products we use. Slowing down the rulemaking process for these vital health and safety protections would put the lives of Americans at greater risk. H.R. 288 could also have the perverse effect of undermining the agency rulemaking process in favor of corporate interests. As the Nonpartisan Congressional Research Service has observed, public participation in agency decision-making is highly sensitive to cost and delay. By imposing greater scrutiny of agency rulemaking, the bill would skew the fact-finding process in favor of those with significant resources. Large corporate interests devoted only to maximizing profits for the benefits of shareholders already have the edge in this process with their vast resources to weaken regulatory standards by burying an agency with paperwork demands and litigation. Rather than giving more opportunities for corporate interests to prevail, we should be evaluating ways to ensure that the voices of the public have a greater role in the rulemaking process through proposals like the Stop Corporate Capture Act, which would bring more transparency and more accountability to the rulemaking process. This legislation is just the latest step in the Republicans' decades-long assault on the regulatory process, trying to add hurdle after hurdle on the ability to issue regulations that protect public health and safety. Regulations whose benefits consistently outweigh their costs, often by many multiples. I urge my colleagues to oppose this dangerously flawed legislation, and I yield back the balance of my time.
Gentleman yields back. The chair recognizes the gentleman from Florida. Oh, excuse me, that's right. We have a amendment, nature of the substitute I want to go to. Ms. Hagman, I apologize. The gentlelady from Wyoming is recognized.
Thank you, Mr. Chairman. This is an amendment in the nature of a substitute, and I have an amendment at the desk.
The clerk will report.
Amendment in the nature of a substitute to H.R. 288.
Without objection, the amendment nature substitute will be considered as read and shall be considered base text for the purpose of the amendment. The chair now recognizes the gentlewoman from Wyoming.
This amendment provides that the Separation of Powers Restoration Act of 2023 may be cited by its acronym, SOPRA, S-O-P-R-A. This change more readily allows this bill to be cited by its commonly known acronym when it is passed into law, and it is not intended in any way to alter the important purpose of this bill. I urge its adoption, and I yield the balance of my time. Thank you.
Gentlelady yields back. Who seeks recognition? Gentleman from Florida is recognized.
Thank you, Mr. Chairman. I used to believe exactly what my colleague from Wyoming used to believe about this legislation, and I used to believe it for exactly the same reasons that she laid out, because it is true that concerns about a growing administrative state are ones that are commonly held throughout the country and certainly commonly held by a majority on this committee. But I have encountered a good amount of conservative scholarship that defends the Chevron decision, which is really what this legislation would overrule. The Chevron decision set forth the principle that in the absence of an ability to determine congressional legislative intent, that rather than the court starting from scratch, that there would be some deference, not unovercomable, but some deference given to the agencies. And the late Justice Scalia wrote very strongly in defense of the Chevron legislation and against the Chevron decision and against what this legislation would bring. And he spoke specifically to this matter, and he said it far better than I could, so I'll read from the late Justice Scalia's writings on this matter. Quote, "The extent to which courts should defer to agency interpretations of law is ultimately a function of Congress's intent on the subject as revealed in the particular statutory scheme. An ambiguity in a statute committed to an agency implementation can be attributed to either of two congressional desires. One, Congress intended a particular result but wasn't clear about it, or two, that Congress had no particular intent on the subject but meant to leave the resolution to the agency. When the former is the case, what we have is genuinely a question of law properly resolved by the courts. But when the latter is the case, when we have a conferral of discretion upon the agency, the only question of law presented to the courts is whether the agency has acted within the scope of its discretion." And Chairman Nadler is entirely correct when he talks about the critique on the right of judicial activism running right up against the ideology that undergirds this legislation. You cannot critique judicial activism, as so many on the right have done for decades, and then say, but what we really want as a result of SOPRA is a more activist judiciary. Scalia continues, "In the vast majority of cases, I expect that Congress neither, one, intended a single result, or two, meant to confer discretion on an agency, but rather, three, didn't think about the matter at all. If I am correct, then any rule adopted in this field results from a fictional presumed intent and operates principally as a background rule of law against which Congress can legislate. If that is the principal function to be served, Chevron is unquestionably better than what preceded it. Congress now knows that the ambiguity it creates, whether intentionally or unintentionally, will be resolved within the bounds of permissible interpretation, not by the courts, but by a particular agency whose biases are well known." Scalia writes, if we have to serve up these questions to an entity other than Congress, at least with the agencies, there's a greater degree of predictability with the courts. And that is no defense of the agencies so much as it is a critique of the federal court system and the disparate outcomes that can be created. In Scalia's piece, he also talks about the need for government flexibility and observes that if the court always has to overrule itself, it does so very begrudgingly in frequent circumstances, whereas agencies admitting they get it wrong is not wrong as to a de novo question of law, but wrong as to a particular series of events. And Scalia opines that government is better served under that observation. There's also substantial historical basis for Chevron. You even had Hamilton writing about the importance of energy in the executive. Madison at the Constitutional Convention talked about this argument. He said that when choosing between the executive and the judiciary, quote, the former must get greater latitude than the latter in the administration of the country. And so if that is the case, there's historical precedent. I know the newfangled concern of conservatives is the growing administrative state, and I share that concern, but I think that we don't disagree on the problem. I think just as Ms. Hageman laid it out, she perfectly laid out the problem, but I think the antidote to the problem isn't to overrule Chevron, it is to do a better job in Congress of being clear as to our intent and then to leave fewer of these decisions to these ambiguities. I yield back.
Gentleman's time has expired. I think the gentlewoman from Texas.
Some say that Texas and Florida has much or some in common. I hesitate to go there because my good friend knows that there are challenges in Florida that I cannot counter. He might have something to say about Texas, but we overcome it with good barbecue. But I must say, as the gentleman has enunciated some principles that I think are extremely valid, I would take his last sentence, maybe we need to be better at clarification. But the Administrative Procedure Act has been implemented since 1946. And we have been able to live under the APA. In fact, I remember one of my less interesting but very vital classes in law school was the Administrative Procedure Act that gave a basis for the complementary aspect of government that fits alongside of executive orders, judicial decisions, legislative actions in the United States Congress. And so to weaken that construct that has added to the democratic process of this nation is the direction in which I would like to go. And it seems to me that the gentleman from Florida has made even further advocacies, including the Chevron case, that there is value to not having a protracted judicial review of an administrative procedure action that may have taken quite a bit of extensive writing, research, and yes, the input of the American people. As you well know, once you put a regulation out, there is a period of time, 30, 60 or more days, and even gets extended, for there to be comment. In that instance, the comment is not Republicans and Democrats, it's everyone, including those who are specifically impacted or engaged in the particular topical issue. So the Department of Energy can have, if you will, regulations, and the energy industry participates and provides insight and light to whatever the issue is. Some person could be where they want to challenge it, and if we loosen or lessen the deference to that process, then we have protracted, long judicial proceedings. I think that what is being attempted to do here is one that we should hesitate. Now, I don't want to scare away persons who may be supporting the theory and thesis of my good friend from Florida, but I'm obviously in the corner of the Food and Drug Administration's long years of having a particular pill that did not harm anyone. And they did it on their research. They did it through their processes. It was open to the public comment. I assume medical professionals at that time, pharmaceutical industry might have commented at that time. And we've come full circle because we've got ourselves in the quagmire of trying to interfere with a private choice and a religious choice and an emotional choice and a medical choice by women of this country. We call that reproductive rights. But it may come up on many other issues. many other issues. And this does not negate the purpose for judicial review. I think what this legislation is doing, as I read it, it is extending what we're looking to do is to not have the courts to go de novo on a matter that has been thoroughly researched and approved by an administrative process. Some of the agencies have boards. They have appointees that come from both sides of the aisle. And so it's been vetted in that way as well. Rules by agencies and constitutional and statutory provisions are all part of this process. So I would make the argument that I don't know if we want to add yet another layer of interference with the necessary operation of government that has already been accused of not being timely, being dilatory, being delayed, when we can take the effective work of our agencies, Centers for Disease Control issued some rules that, from my perspective, save lives. Food and Drug Administration has been the stellar agency internationally. A drug gets its star points when it gets the FDA's approval, and the world watches that happen. So I'll conclude my remarks, Mr. Chairman. Your generosity is that I believe that this legislation goes too far in impacting negatively the running of government. I ask opposition,
time has
yield back.
expired and yields back. The gentlelady from Wyoming is recognized for 5 minutes.
Having been a practitioner for over 30 years and having many cases against federal agencies, I can assure you that the courts have moved well beyond deferring to regulatory agencies in ambiguous situations. I'm going to read some of the language from the Rapinos decision that was issued by the United States Supreme Court in 2006 as a way to emphasize this point. According to the decision in that case, the burden of federal regulation on those who would deposit fill material in locations that are denominated as navigable waters of the United States is not trivial. In deciding whether to grant or deny a permit, the U.S. Army Corps of Engineers exercises the discretion of an enlightened despot, relying on such factors as economics, the aesthetics, recreation, and in general, the needs and welfare of the people. The average applicant for an individual permit spends 788 days and $271,596 in completing the process, and the average applicant for nationwide permits spends 313 days and $28,915 in seeking permits. The enforcement proceedings against Mr. Rapinos are a small part of the immense expansion of federal regulation of land use that has occurred under the Clean Water Act without any change in the governing statute. I will repeat that, without any change in the governing statute. During the past 5 presidential administrations, in the last 3 decades, the Corps and the EPA have interpreted their jurisdiction over the navigable waters of the United States to cover 270 to 300 million acres of swampy lands in the United States, including half of Alaska and an area the size of California in the lower 48 states. And that was just the beginning. The Corps has also asserted jurisdiction over virtually any parcel of land containing a channel or conduit, whether man-made or natural, broad or narrow, permitted or ephemeral, through which rainwater or drainage may occasionally or intermittently flow. On this view, the federally regulated navigable waters of the United States include storm drains, roadside ditches, ripples of sand in the desert that may contain water once a year, and lands that are covered by floodwaters once every 100 years. Because they include the land containing storm sewers and desert washes, the statutory navigable waters of the United States engulf entire cities and immense arid wastelands. In fact, the entire land area of the United States lies in some drainage basin, and an endless network of visible channels furrows the entire surface, containing water ephemerally wherever the rain falls. Any plot of land containing such a channel may potentially be regulated as a, quote, navigable water of the United States. Why do I read that? Because courts have been deferring to that nonsense now for decades in terms of the immense expansion of the EPA and Corps of Engineers authority over what is defined in the Act as a navigable water of the United States. How have they been able to do that? Because the courts have been abdicating their responsibilities of deciding questions of law de novo, and they have allowed the agencies to make those decisions. That's why this act is so important, the Separation of Powers Restoration Act of 2023. I can understand what my colleague is saying about the concerns of courts making the decisions, but we're not talking about activist judges actually doing their job if they are reviewing statutory and regulatory documents, laws de novo. It is when they defer to the agencies that they fail to do their jobs. Having been someone who has tried numerous cases against the EPA, for example, or the Corps of Engineers, or the USDA, or the Forest Service, or Fish and Wildlife Service, I can assure you that when I represent farmers and ranchers, oil and gas companies, other resource producers, and small businesses, when I walk in the courtroom because of the deference doctrine, typically what you're seeing is that I've already lost the case. And then what I have to do is overtry it because of the deference doctrine. So what the deference doctrine actually does is it places the thumb on the scale of the administrative agency against the citizens of this country, the exact opposite of what is the foundation of America and what is the foundation of our form of government. We don't work for the government works for us. Yet with the deference doctrine, what has happened is these administrative agencies have taken over so much power and authority simply by claiming that a statute or a regulation or even now a guidance document is ambiguous, and therefore they must be the ones to interpret it, and the courts need to stay out of it. This is a good bill. It serves a great purpose of putting the regulatory agencies back in their lane, of only carrying out the law as Congress wrote it, not actually interpreting it as our judicial branch is required to do. With that, I yield back.
Gentlelady yields back. The gentleman from Georgia is recognized.
Thank you, Mr. Chairman. I rise in opposition to this legislation. There's a reason why Republicans have been about packing the United States Supreme Court over the last 40 years, over the last 50 years, to the point now where they have a 6-3 supermajority of right-wing Republicans on the bench ruling in favor of corporations. The reason why they wanted to pack the court is so that they could pass legislation like this, which puts it in the hands of the United States Supreme Court to rule on agency rulemaking, to be a super rulemaker, in other words, to put the Supreme Court in a position to decide what is best for the health and safety and well-being of Americans through oversight of regulatory authority. The FDA, for instance, Food and Drug Administration, when they issue a rule that would protect the health, safety, and well-being of Americans, and they do that, let's take mifepristone, for example, a drug that induces miscarriages in women who are in need of that medical procedure. They want a court that is empowered to overrule the agency rulemaking process and rule that that medication is not efficacious without any support, without any factual basis, without any expert factual basis. They want to put the court in a position to do that. And the court is basically packed at this point and awaiting congressional passage of legislation like this so that they can do exactly what I said to do, and which is to overrule agency rulemaking that will protect the health, safety, and well-being of Americans. That agency rulemaking is based on laws passed by Congress, laws that, and I'll point out the fact that if you expect every rule to be mandated or passed by the House of Representatives and then the Senate and then the President, we basically would have no rules. It would be a free market economy with no rules or regulations to protect the people. This is what the Republicans want to accomplish in this country. They want to do away with government. That's why they talk about less government, defund the government. They want to reduce the size of government to the point where you can strangle it in the bathtub. That's why they have all signed on to the Grover Norquist no new tax pledge. And so, you know, they are killing us. They're killing us, literally, with their pursuit of free market capitalism so that the rich get richer, the poor get poorer, and there's no protection for the little guy, for the health, safety, and well-being of the little guy. So this legislation I oppose. It is a race to the bottom of our democracy for capitalism to take hold of freedom and to drive it into the dirt. That is what this kind of legislation does to our living here in this country. It's very destructive, and it seems to be increasing its stranglehold. First, you have Republicans who control the House offering legislation. Next, they will want to control the Senate so that they can pass this legislation and then send it to the courts, which they have packed, which are then in position to do away with all regulations to protect health, safety, and well-being of Americans. Dangerous road to go down. Let's not do this. I oppose this legislation, and I yield back.
Gentleman yields back. Chair recognizes himself. I don't want to do away with government. I just want those who are elected to office by we, the people, by the American citizens, to actually make the laws. Imagine that. But that's not what the Democrats want. That's not what they want. They want to defer to the bureaucrats. That's what Mr. Nadler said in his opening statement. He said, quote, "We don't have the expertise." Well, who does? The unelected bureaucrats? The people in the agencies who never have to go out, shake hands, talk to the American people, get elected to office? The people who aren't elected by the American people? I mean, leave it to the experts, the Democrats say. Well, who's the expert who ran our lives? I've talked about this a lot because it drives me crazy. Who's the expert who ran our lives for the last 3 years? Who's the expert? Served longer in our government than anyone else. The bureaucrat is Dr. Fauci. Dr. Fauci, the smartest man on the planet, never been wrong, except in just about everything he told us about the virus. Remember when Dr. Fauci said it wasn't our tax money that went to that lab in China? Wasn't right about that one. Remember when he said it wasn't gain-of-function research? Wrong about that one. Remember when he said it didn't come from a lab? I will not. Remember when he said it didn't come from a lab? Sure looks like it did. Remember when they told us the longest-serving bureaucrat in the government, the smartest man on the planet, told us that the vaccinated couldn't get it? Remember when he told us that? Remember when he told us the vaccinated couldn't transmit the virus? Then he told us there's no natural immunity. First virus in history. No natural immunity. That from the expert. So while I appreciate the arguments from Mr. Gates, and I think he makes some good points, and I think there is a balance here when we're talking about the courts and the agencies, what bothers me the most and why I support the gentlelady's legislation is because I am so tired of this argument that we got to leave it to the experts, the bureaucrats who know more than the folks who actually go out and talk to the American people, put their name on the ballot. In the case of Congress, every 2 years put their name on the ballot and get elected to office. They should be making the decisions. Yield to the gentleman from New Jersey.
Chairman, I want to agree with you, and I agree with the lady's legislation very much. I got to tell you, I've had the, experience of being a state senator, a state assemblyman, a county commissioner, a mayor. I've dealt with a lot of regulatory agencies, more than most people in Congress, to be honest with you. And to say that they always do a better job, they're often very slow, very bureaucratic, very opinionated, not by any means always right. And Fauci used the example, which is the best one of all. And on top of all the things that they do, this is not the same regulatory agencies that we were used to when this process was started many years ago. Many of them are tied to politically, and involved with politically people who want to get a certain outcome. And I've seen it, Chairman. I've seen it over and over again where they desire to have a particular outcome. They work within the agency. And if you don't think that our president right now has effect on the agencies and what they're saying or doing, or that other people don't in positions of authority, you're wrong. It's an imperfect system. I don't love the courts either, to be honest with you, at all times, but at least there you have a fair and expeditious chance to be heard and to have some say in what the ultimate result is going to be. So after the literal pain I've gone through dealing with these agencies, and it could be DEP, which is the EPA of New Jersey, or it can be the EPA, or it can be the health organizations. And by the way, some of the examples that are used, these folks have made horrific mistakes. They've made terrible mistakes. So in a court of law where you may have experts come and speak on both sides of an issue and intelligently thrash it out, I think that there's value to that. And I think we should really see that value. And finally, yes, Congress should do a better job. One thing, legislative intent. We want to have legislative intent where we really get something done, but we get it done the way that we envision it. These agencies change it. Our legislative intent, over half of the time, is not the legislative intent that they see and they feel and that they enact. So I think it's time we did something like this. I support your bill.
Will the gentleman yield?
15 seconds.
One can disagree with this bill and certainly not agree in deference to the agencies in every circumstance. I would simply offer that bills like the REINS Act, which we've debated in this committee, might be better antidotes to the problem.
We plan on bringing that. That's a great point from the gentleman from Florida. We do have votes that have been called on the floor. I understand there are 3, and I believe I've been told that we're getting a picture today. Is a picture day today? So the committee will recess because I understand the Democrats have some amendments they want to offer to this legislation. I think that's accurate. Okay. So we will recess, and we will get a notice out to when we're going to come back. I want to talk with members and see what they have this evening. So we will probably come back this evening, but it may be tomorrow. I just want to check with our members, and I'll check with the ranking member as well. So with that, the committee stands in recess.